Mr. Hill.
So before moving on to the second point, I just wanted to make one very brief point about the duty of single-minded loyalty. To pick up what my Lord Justice Nugee said yesterday about the duty of loyalty being different in nature to a duty to maintain a professional standard of service, we accept that the duties have a different scope and extend to cover different things. That said, a deliberate decision, for example, to provide a substandard service could, of course, be a breach of both duties. And in this case, we also accept that in the contract, there are aspects of the services which require acting in good faith. Sometimes it's provided expressly so, for example, clause 7.4. But that isn't a duty which extends across the board, we say, nor, as was pointed out by Lady Justice Falk in the second of the appeals before this one, paragraphs 45 to 48 of her judgment, which you can find at tab 10 of Authorities Bundle 1. I think you need to turn it up, but on page 221 of that bundle, she said that the concept of good faith couldn't expand the scope of the duties essentially under the services agreement. What it could do was condition the way they acted within the confines of the agreement, if in a particular case there was a requirement to imply a duty of good faith. And here we would of course accept that there may be aspects of loyalty involved. So for example, if LLP went to clients of the legacy business and surreptitiously tried to persuade them to abandon the business in order to avoid paying, avoid having to service them at the 57% revenue share they get under the clause 9.1 of the agreement. Now, if they were to do that, we would say that would be a breach of clause 8.4 of the agreement, which is that requires all reasonable endeavours to be used to avoid doing anything which might prejudice or bring into disrepute in any manner the business or reputation of court. But we would say it goes no further than that. The agreement sets out how far one has to go, and there's no requirement to go to a sort of more onerous fiduciary duty or to look into the case law on relational contracts to go any further. So, after that brief comment on the first of our grounds, I'll move on to our second ground, concurrent goodwills. Now, first of all, a section of the judgment on rights in goodwill, which one finds at paragraphs 44 to 76 of the judgment, does not culminate with an express statement, Quad owns all the goodwill associated with the mark, as one might expect. But that is in fact what the judge has found. And if I could just take you to the judgment, we can see that from paragraph 73b on page 175 to 13 in the core bundle. So we find here he's rejecting the contention that there was an implicit agreement for concurrent goodwill and then we can see this picked up later in the judgment at paragraph 114, which is dealing with the question of justification. That's on page 191. And the judge says, Quad, not LLP, was the proprietor of the mark and had a goodwill associated with it. Remained the proprietor of the mark and continued to use it. LLP had only a permissive right by license to use the mark during the substance of the relationship between the parties. It had its own goodwill, its own business, it never acquired more than a license to use the mark. So the goodwill that LLP had did not extend to the mark, it didn't attach to the mark. And of course that was our case at trial, which was that there was a separate goodwill, and quite clearly the judge rejected that. Because he rejected it, he didn't deal with the arguments about sort of honest concurrent use of separate goodwills, which should be mounted at trial. Now, so we say the court is wrong in its appeal skeleton to suggest the judge did not decide that the LLP did not own goodwill associated with the mark. That appears to be suggested in paragraph 132 of Quad Skeleton at page 37 of the skeleton. Perhaps it's entirely precise as to whether it's saying that. But what we do say is that it's clear the judge did reach that decision. And the way the judge reached that decision was to find that there was a collateral, indeed somewhat prior license agreement to the services agreement, of which it was a term that the goodwill would accrue to Quad. But of course the judge doesn't, in fact, analyse what the terms were. Paragraph 69 of the judgment on page 173 you'll see his finding here. He's concluded there's a license, there was an agreement, an express agreement in 2007, which he reaches the conclusion there was such, however vague and imperfect may be the recollections of what was discussed, which we say is a very promising starting point for reaching such an agreement, such a conclusion. And we could see also, he said he should have interpreted the license to come up with that result, again relying upon there being such a collateral license. Now, we say that simply...
Is that right? Or is he saying even if I'm wrong and there's no collateral license, I would imply such a collateral license into the services agreement?
Perhaps he is saying that, in which case I'll address the question of what the services agreement says about the license.
That should be quite quick because it doesn't say anything.
Yes. So that's our point. There's no such implied license. There's no room for it because there's plenty of room for disagreement about what such a license might provide for. There's termination provisions. You see multiple licenses which have different approaches to these questions, and so it's not a case of there is a Liverpool and Irwin type form of term which is implied without having to go into the Marks and Spencer test, and it's not a Marks and Spencer test either, because in the Marks and Spencer question you have to basically be able to say, well, it's bound to be this, and you can't. Is our simple point on that. But going back to this question about what the judge decided in terms of there being this collateral license, we say that simply wasn't available to him on the pleadings. Because if one thinks about it, that case is essentially, if you were to plead it normally, you'd be saying, and I should say that it's a claim that the relevant claim here, which we can see from Supplemental Bundle tab 1, page 2, is here we've got the declaration, it's paragraph 6 of the prayer, the declaration of what is entitled to the goodwill in the name of advisory, and that is taken up in the particulars of claim. Again, paragraph 6 of the prayer, page 10, paragraph 21 of the body. But what we don't have, which one would normally have if one is basing a claim, which one has to have, we submit, if one is basing a claim on a contract, is a plea saying there was a license agreement dated X, arrived at in writing, or arrived at by words said in conversation or communications, or by conduct setting out as required by Practice Direction 16 of the CPR.
But the claim to the goodwill in quantum advice, the name quantum advisory, which I think is what you showed us, isn't a contractual claim. It's not saying as a matter of contract it was agreed that we should have the goodwill. The basis for the claim is we were trading under the name Quantum Advisory before you ever appeared, before you ever existed. What we've done through the services agreement is one thing, but we still retain what we always had before you came along. So it's not a contractual claim as such, is it?
Well, we say it is.
It is.
We say there are two goodwills here. We say, first of all, you've got the goodwill in the legacy business, where your point is entirely correct. That was carrying on. That was in existence at 2007. It carried on, continuing to ultimately have a trade origin being caused thereafter. But as for the LLP business, that's different, because actually the default position is LLP starts, as a matter of fact, the trade origin throughout the life of the services agreement in relation to LLP services is LLP. So the default position, as established in the Scandicor decision of the Court of Appeal, is one works out what is the trade origin, and then one departs from it by contract, if there is a contract. And so we say it is necessary for there to be a contract in order for the goodwill relating to LLP business to go otherwise than to the trade origin as a matter of fact, and to fall and devolve to quad. And so,
Well, this may just be a pleading point. Maybe they can start off by saying, before 2007, we built up a business using the name Quantum Advisory, so we have goodwill in it. Then for you to say, after 2007, we used, with your consent, the name Quantum Advisory, both for your business and for our business, so we've built up a concurrent goodwill in it, and then for them to come back and say, no, that trading by you under the name Quantum Advisory was solely attributable to a license that was coterminous with the services agreement. But it's not obvious they need to plead it in the first instance.
well, we would say they're seeking a declaration as to ownership of all the goodwill. They know that there are two businesses. We say that if you're going to maintain that argument based on a contractual term, you ought to plead it.
I see.
And we say that should be done in a particular claim. But we also say, even if it was a matter for reply, it's not even done in the reply.
Well, what did you say in response to this?
So we, so our response was, it's paragraph 7 on tab 3 in supplemental bundle, page 14.
Yeah.
So the essence, from the second hole punch, we're saying the essence of the reorganisation was therefore to permit LLP to develop a separate goodwill attaching to the mark which should exist concurrently with the old Quad's goodwill. And then we point to the services agreement. I'm not saying anything about it. And the response, as far as it goes in the reply, is in paragraph 7. And 7.5 just says permission ended termination.
What's wrong with that? Permission to use the name and mark would be terminated immediately upon the termination or expiration of the services agreement. That's what the judge has found.
Well, no, it doesn't. It doesn't deal with the question of whether a separate goodwill arises, which is the point which attaching to the mark, which is the point on which we found our section 10b argument, which is we have a legitimate interest in a separate goodwill attaching to that mark, which we validly want to protect using the trademark.
Even if your permission to use the name, the mark, is temporary, it's terminable.
Well, there's a second point to that, which is that we also say, of course, that we don't need permission in respect of a separate goodwill. A separate independent goodwill, you don't actually need a permission
Then you must have had, if they had, which I think is common ground, an existing goodwill in the name and mark Quantum Advisory in 2007, before you came along, you must have been given permission to use it for your own business.
At the beginning, we did. At the
Yes.
beginning, we did. I'm going to come on to this point, but as time develops, that ceases to be the position once a separate independent goodwill has accrued.
Even
and
if
the equity of the position is that.
Even if the permission from the outset is temporary, that is, I mean, it's quite a long time. It could be 99 years, but it's.
Well, it rather depends on the nature of the permission, doesn't it? Is what we would say, and we say that the nature of the permission was to enable the establishment of a separate goodwill, which would have its own life and which would not necessarily be constrained, and therefore, because that otherwise you run into the problem of the, as I would characterise it, the windfall at the end point, which is that as time goes by, one has a case where the goodwill of the LLP is sort of overwhelms any goodwill of Quad, and if you adopt the position that you continue to need Quad's permission to be able to continue to use the mark at that point in time, essentially you grant a windfall to Quad.
I'm sorry, I've been very slow. I haven't quite understood this. You're showing us the pleadings because this all comes in under the rubric of you never pleaded the license.
Yes.
License is just another word for permission. But this is a pleading that you were given permission to use the name and mark, but it was limited. What is wrong with that? Well, as a matter of pleading, what's wrong with saying, yes, we did let you use it for your own business, but you had to stop using it and the services agreement came to an end, which is what this says.
Well, that's not actually what. That doesn't. First of all, it doesn't engage with our argument that we have a separate goodwill entitled to, which is highly relevant because if one looks at the case where you don't know what the position regarding Quad's goodwill will be in the future. So, say Quad's goodwill in legacy business has expired. There is no legacy business after a certain point in time. Now, then it becomes highly salient as to where goodwill accruing from LLP's business ends up being sitting. Because if that's going back to Quad, LLP will be continuing to maintain essentially a right for Quad. And so when you come to the end, LLP will not be able to essentially carry on.
But you need to decide, do you not, as a matter of fact, whether the permission that was granted in the first place was, as the judge found, coterminous with the services agreement, or whether it wasn't. Then you can argue what the consequences are for LLP's use of the name in relation to its own business when the permission it has to use that name is a limited one. But I don't see why it's impermissible for the judge to embark on the question of the nature of the permission that was granted.
Well, what I would say is impermissible is first, it's not pleaded as to where this permission arises. I would entirely accept it was perfectly permissible to rely upon the services agreement and to interpret that and to decide whether there was a permission and what it was. What I would say is not pleaded is any sufficient allegations as to where a different contractual permission arose. And I would say that should have been in the particulars of the claim, and at the very least it should have been in the reply, and it's not sufficiently in the reply. because all we see said is what we have in clause in paragraph 7.5 and 7.7 and 7.8. Which are not sufficient as a matter of pleading ones to rely upon a contract, we say. And in any event, what one gets to the position which we say is unsustainable on the facts is that when one looks at what the judge has essentially found that position to arise from, it is from inconclusive materials, people expressing particular points of view well before the services agreement, which is, we would say, inconsistent with the fact that the services agreement was clearly the document intended to govern the relationship between the parties.
I think you agreed the services agreement doesn't say anything about goodwill or the right to use the name or anything, does it?
Well, the judge actually held that it did, you see,
Oh,
because the judge held that goodwill was an asset.
Yes.
The existing goodwill was an asset, and what the agreement says is you can use an asset during the life of the agreement, but upon termination you need to stop. So in a way, the services agreement it did provide for continuing to use the goodwill. But what it doesn't do, we say, is deal with the question as to, well, do you even need permission to continue to use? And we say, where you've got a separate goodwill in the context of this agreement, you don't need permission. You've got a separate goodwill which entitles you to carry on alongside, and indeed that was the very purpose of the agreement, and that's the only way of dealing with this problem of the freeloading at the end.
Can it really have been the intention to say the parties to agree that yes, Quad has an existing goodwill. Yes, LLP has permission to use that goodwill during the course of the license, or permission. But at the end of the agreement or the permission, it's only to hand back the goodwill that was the pre-existing goodwill and not accretions to that goodwill that are generated in the course of the license. And it wouldn't apply most implied terms test, wouldn't you say, well, of course, it's not just the it's impossible to
hand back
just the pre-existing goodwill. You've got to give up the whole thing.
That would be, in most agreements, that is indeed the case. So in the Dorney Day
Why is it
example,
not in this agreement by implication?
well, because this agreement is a very specific arrangement, which is intended to facilitate a divestment, a conveying over from Quad to LLP. So it's a quite different situation to the normal one, where the licensor has an ongoing intent to be there at the end of the day. At Dorney Day, there's a group of companies into which a partnership company is then brought, and then when it leaves, it has to stop. That's entirely normal. And by the ordinary application of the Marks and Spencer approach, you would imply a term if it wasn't there. But that isn't what we say you can do here, because there's quite a different end game at work. And you can't assume that the partners of the LLP, some of whom weren't Quad members, so the LLP had incoming, I think, 2 new partners, and Quad had one main person, Mr. Coombs, who wasn't going to carry on into the LP. One can't assume that everyone essentially all agree together as to what the end result ought to be. And in those circumstances, one comes down to, well, it hasn't been provided for. And the sensible course we submit is that LLP has its own rights. And I should also point to the Croom decision, which my learned friend I think mentioned, which is at bundle 2. Sorry, maybe it's, no, I think it's authorities bundle 1. page 45, that's paragraph 45 on page 311, what Mr. Hobbs, Queen's Counsel, there said is he said the approach is where one has separate goodwills. Senior user prevails over the junior user. Junior user cannot deny the senior user's rights. Senior user can challenge junior user.
Sorry, where are you reading from?
Paragraph 45.
Thank you.
Senior user can challenge the junior user unless and until it is inequitable for him to do so. So in this particular arrangement, at the beginning, one might say, well, it would be inequitable if there's a termination very shortly into the life of the services agreement where LLP has not really got off the ground, for LLP to say, well, we should be able to carry on. But later on, when the position is entirely different and LLP has, through its own efforts, built up much the bigger goodwill, we say quite a different answer can be reached, just applying that general principle. And we also say that, in fact, it doesn't need to be decided, because this isn't a case where, of course, we're considering at this point in time, a question of, is someone passing off? There is, of course, no passing off at the moment, either way, because there's definitely a permission, if it's required, from Quad to LLP to make use of assets. And the other way around, obviously, Quad is just continuing to use its earlier right. And what I would just say is, of course, one never needs to decide this question. In fact, one might never need to decide this question. So, of course, if the legacy business ends at some point in time before the LLP business, there is going to be no, on our analysis, there will be no legacy goodwill. So there will be no question of passing off. But there will be LLP with its own goodwill attaching to the mark. And our position is that is something which we are now entitled to protect. And I'll come back to the justification argument. But LLP has this goodwill which is building up along now. And irrespective of how one answers that question over time, we see there is a chance that at the end of the day, there will be no legacy business. There will be no Quad right to interfere with LLP. So even if you don't accept our position that LLP is already free from the right, there is a valid LLP interest which can be called upon for justification purposes. And I'll come back to that point on the third ground.
Can I just ask one thing? Going back a bit in your submissions, you draw a distinction between the position at the beginning and the position later. So at the beginning, you've got Quad having goodwill, and you then making use of Quad's goodwill on a license basis. Is that fair?
Yes.
Over time, your business gets going. Why, nevertheless, should one infer that there's been any change in the arrangement? I mean, if you've been licensed at the start to use the goodwill, why shouldn't that remain the case?
Well, what we say is that that's the very intent of the arrangement, which is we're giving you these assets to build your own business. We don't want to be there, essentially, at the end. We want to extract our value over a long period of time. And the only way of actually doing justice to that and recognising that LLP is to build its own business and not to actually strip away a valuable part of it is to approach it on our analysis. And our analysis, we say, doesn't actually end up with any significant drawbacks for Quad, because Quad, if it's early in the life of the business, Quad will take back its business under the exit arrangements. It will be able to essentially take back all of its assets plus staff. It will basically hollow out LLP. So it will essentially then resume things. But as time goes on and it goes around the other way, it will of course then have got its value. And the justice of the situation, we say, is that then LLP will be in the dominant position. But that's an entirely understandable and fair approach for the parties to have agreed, given the way they were looking at dealing with matters.
Where is the tipping point in theory?
Well, I don't think we need to make a specific decision on that. The fact is,
no, but we must at least, if this is how the arrangement works, it must at least be possible to articulate a theoretical point at which it shifts.
Well, I think it's basically once the LLP has established a significant independent business of its own, you do then have on the proper analysis an uncomfortable period of, if things really didn't work out at that point in time and there was a breach and there had to be a termination, you could have a situation of two people alongside each other, which of course is not ideal. but that is actually something which surprisingly often occurs in the cases, because the parties don't want to resolve those difficult questions. So you see it in like the Heyman-Joyce decision, which I'll come back to, but also in many other decisions of the past involve two parties where things have come apart, and you have two people with rights in the same name alongside each other, and it's uncomfortable for them. But the risk of it actually happening in real life is of course low in the context of this case. And so it's entirely understandable why people actually wouldn't want to address it. And really that's part of why they got into extending the agreement, because they didn't want to hammer out the hard work of what termination might look like. So if you make it extra long, you're basically saying, well, actually at the end of it, it's going to be the LLP position is the fair one, and we don't need to really grapple with what's going on in the intervening period, because it's very unlikely that this is actually going to fall apart, given the sort of nature of what this deal is. So if I could just move on then to some of the well, I think I've commented on pleading. We say it's inadequate to sustain what the judge has done in relation to the facts, and then when one actually looks at his conclusions on the facts, what the judge has actually signified is that these are all recollections, imperfect as they are, and that absent a clear pleading in particular, but even without that, they were insufficient to conclude that there was a clear license agreement, and he ought to basically, in any event, consistent with his finding that goodwill was an asset, have stuck with the services agreement as the foundation of the relationship. And so he went wrong in finding a separate agreement.
Sorry. I was going to say, do you agree? Was the judge right to say that goodwill is an asset? Would you challenge that?
No, we do agree with that.
You agree?
I think at trial we didn't agree with it, but on analysis I think it's correct, because you do use goodwill in a business. You do want it an entirely fair way of saying what one does with goodwill. One uses the attractive force to bring in business. And goodwill is generally regarded as an asset anyway.
And you're moving on to the substantive point. Just before you leave the pleading point, you say, well, it's not properly pleaded. Suppose that were our conclusion. Does any injustice arise from any inadequacy in the pleading?
Well, we say yes, because the evidence could have been different if it was said, well, this is actually where the agreement arose. Certainly speaking for myself and outside, the preparation for the case would be quite different. It would be, well, actually, no, there was no agreement at this point in time. Mr. X of the LLP knew nothing about this and didn't agree to it, and his agreement was necessary for things like that, none of which was, of course, explored.
Yes, I see.
So going on to the substantive position, first of all, I've mentioned Scandicor as setting out the standard sort of position as to where goodwill arises. I'll give you the reference. It's paragraphs 38 to 40 of that judgment. Civil Authorities Bundle 1, tab 12, pages 274 to 6. I don't think we need to go to it, but what it reflects, and it's reflected in, is the Hayman-Joyce decision, which one has at Bundle 2. Tab 26. Page 556. It should say this judgment occurred, the Hayman-Joyce judgment, post-dates the trial judgment. And in fact, it refers to the trial judgment, so obviously the judge didn't. But at 556, we see paragraph 31. The judge is essentially reflecting what comes out of scandal. So first of all, she recognised it's possible for several businesses using the same name to acquire their own goodwill, and it can have been evolved independently or evolved from a common ancestor. There's no sort of specific limit to how it might have arisen. And that what the position is, first of all, is a question of particular facts of the case. So depending on factually who is the trade origin is the starting point, and then supervening on that, what are the agreed? What's agreed? Or there could be other legal relationships which would come into it. So there's a directorship, that might also affect the position. And this case is an interesting one. It involved two estate agents based in the Cotswolds. The first being established by James Hayman-Joyce and Morton on Marsh, and establishing a goodwill around the Cotswolds, which extended to cover Broadway. And then subsequently, he went into partnership with another man, the second defendant, and they set up an office in the Broadway area, again under the name, using the same domain name, website, etc., which was to cater for the Broadway area. And the way the judge has analysed it is that there was essentially going to be two goodwills under the nature of the partnership agreement. So there was a goodwill in the Morton Marsh area with the old business, there was a goodwill in the Broadway area with the new business, and then there was also the rest of the world where they had a shared permission to carry on business. And of course, in the rest of the world area, there is inherently two businesses operating under the same name, and a possibility of confusion arising from that. But that is what the parties have agreed and is tolerated and cannot be objected to by either one. So there are two with the goodwill. And so what the position we characterise this case as being, in a sense, is in the rest of the world type situation. Because here there is no geographical split, of course, in relation. Well, we don't rely upon a geographical split in the way that the businesses, the clients are distributed around the UK. And so it's instead...
You're based in Cardiff, but in practice provide services throughout the UK, is that right?
That's right. I think at the beginning there was more of a focus. So when
some of the legacy clients are distinctively Welsh clients.
Yes.
But nowadays you're a UK-wide business.
That's correct. But I think even at the beginning it wasn't entirely limited to nearly all, I think is the position, but I shouldn't say. So anyway, we put this case in the sort of position of the rest of the world, as it were, in the Hayman-Joyce position. And what the judge at paragraph 43 of her judgment goes through the analysis of how the position could be first of all, the claimant puts forward three ways of dealing with it. So first, there was a license under which goodwill accrued to the licensor. Secondly, there was potentially assignment or severance of goodwill. And what the judge has essentially concluded on the facts of this case was, if you can see in paragraph 45, she has concluded, first of all, because there's the partnership agreement, this isn't just an implied license as in the nature of Dawning Day, and she then refers to this case, but she obviously proceeding on the basis that it was rightly decided.
Sorry, which paragraph?
Paragraph 45.
45. Yeah.
So the footing, all the goodwill is basically sitting with the senior user. But she says that that doesn't apply here because of the partnership agreement, because that has a specific arrangement. What we actually say in this case is, well, here, the services agreement, in fact, when one properly construes it against its background, provides a reason as to why this isn't the Dawning Day type situation, but it's actually more akin to what the judge decided in Heyman Joyce.
Do you agree with the first sentence of the quotation from Wadlow in paragraph 43? Is that a correct statement of the law?
Well, we would say that is not entirely correct. I think it's correct as a matter of practical reality, that in almost all cases there will be an implied term based on the Marks and Spencer principle, we say, where goodwill goes back to the licensor. As a matter of practice, that's right, but I think we would say that the analysis that one implies one almost as a matter of law, unless there's an agreement to the contrary, it isn't quite correct. And that this isn't, because there are many different types of license agreement, there isn't, I think this may be sort of more of the Liverpool Irwin type analysis, which we say isn't appropriate. In fact, this is with licenses, you have to work on Marks and Spencer type approach, but in practice, you end up with the same result. Almost always. But in any event, we'd say here we do actually have an agreement properly construed, which is to the contrary, or alternatively supervening factors. So we would say that it's not, even if that was entirely accurate, it wouldn't actually make a difference in the facts of this case.
Is there anything in the services agreement which reflects what you have described as the commercial impetus for it, which is that it was a way for LLP to build up its own business using Quad's existing goodwill?
Well, it's not only its existing goodwill, but it's all its assets.
All its assets, but
that is.
I mean, the findings of a judge, both in this case and I think in the earlier case he had, was that the reason for the services agreement was that you wanted to effectively buy out the owners of Quad, but didn't have the cash to do so, and you were acquiring what he called a turnkey business, and paying for it by servicing the legacy clients.
So the way that the fee split was set was, of course, on a sort of non-profit making level on the legacy business. So what really happened is you're not really acquiring a turn, you're acquiring the means of running a business from
Without having to build
without
from
having to
scratch.
have all the money to buy it.
Yes, I see.
So all the assets, all the people, and again, of course, publicity, ability to reach out to clients. You're getting all that basically given to you, and it's implicit. It is implicit in the services agreement in the making available. So 7.2 on page 213. It's not clear in this, but what I submit is the clear when one actually looks at the background. The intent here is, in addition, Quad shall make available the assets to the RP in order to enable it to perform the services. Now, core to that is under an arrangement where you've set a very high fee split in relation to the legacy business, it is obviously necessary for those assets to be made available for use by the LLP for other purposes, for its own purposes. So this is, although it says in order to enable it to perform the services, and in some circumstances one might read that as saying, well, that's the only reason you can use the assets. We're giving them to you just to perform the services. We say, actually, in the context of the services agreement, it's the opposite to that, really. It's that we're giving them to you for your own use as well. And that's the foundation. That's the only way you'll actually be able to provide the services to us, because you need to be able to have your own business in order to be able to have any long-term prospect of actually meaningfully providing the services.
I mean, the difficulty with that, as you're recognising, is that on the face of it, this clause says the opposite. It confines your right to use the assets to use to perform the services. And that's consistent with the judge's view that, yes, you have to have a right to use the assets, but that right has to be external.
Well, we'd say that there's no reason to construe it in that way, because actually it doesn't say you can only use the assets for the purposes of providing the services. It doesn't say that, which is significant. And it read against the context that they're all made available, and that there is no, if you look at what the assets are, they are things like office materials, things like that, which clearly the intent against the backdrop of it has to be read as well. You're going to be using those generally. You're having all the staff, you're having all of the desks and things that they use. They've got to be using it for both. You can't expect them to go into another room and rather Chief's example perhaps, in order to service the new business. So although as I say, in some circumstances, if you just took this out of the context of this particular arrangement, you might read it as my lord says. We say here it actually means very clearly the different approach. It's saying we're giving you all the assets for your use, and you use them as you want. But you're going to be providing us with the services, but you can also do anything else you like with them, so long as you comply with the other requirements in 7.3 to 7.5. So you give us the good services which are to the contractual standard, and as long as you, in relation to, you don't damage them, you don't prejudice our business, clause 8.4.
So 7.2 also says at the end, when the services agreement comes to an end, you have to give the assets back. So to take your trivial example, desks. Even if you can use the desks both for the legacy business and your own business while the services agreement is in place, were it to terminate, you'd have to give the desks back. And if you wanted to carry on servicing any of your own clients, you'd have to buy new desks. That's what it says.
That is correct. And of course, so that, of course, at the beginning of the business, when with physical assets and things like that, would, of course, be a major problem if there was a termination. But it's inherent that, obviously, Quad in those circumstances will be wanting to restart. When one looks at it in the future, in the distant future, with things like physical assets,
there are probably very few assets.
There will be very few assets
left. But once you've accepted that goodwill is the judge was right to say goodwill is an asset within the meaning of this, why is it not the same with goodwill? That you can use it to enable you to perform the services. Like a desk, you can also use it for your own business, which is what happened. You used the get-up to sell to clients without distinction between legacy clients and your own clients. When it comes to an end, you have to give it back.
Well,
like the desk.
It's slightly curious that you don't, in a way, there's no giving it, in a sense, but permission stopped us.
Well, in terms of goodwill, if you have to give the goodwill to the licensor, like Wadlow says, when the license comes to an end, the goodwill accrues to the licensor. What it in practice means is the licensee no longer can use it. Isn't that what it means with a non-physical asset like goodwill?
Well, what we say is it means, in the context of this, it means that, question, if your permission ends, does that mean that you actually need a permission? So obviously, Quad, at the end of the contract, Quad begins to be able to use its own goodwill, and we can't use its goodwill. But do we need to use its goodwill in order to service our business? We say no. We say, one, you can have concurrent goodwills, and if you look at the Croom account, over time you can build up a junior goodwill, which is, in the circumstances, permitted to be freestanding. And secondly, of course, there's the possibility in the long term of there being no Quad goodwill. And so there's nothing to return in that case, in which case one has the question, well, there's a separate goodwill to be building up in the meantime, and that ought to be, on our analysis, that ought to be sitting with LLP. And so LLP is then the last man standing and is entitled to a trademark. And that is sufficient, we say, then come on to the third point, is sufficient for the justification argument. The other point I just wanted to make based on Heyman Joyce is in relation to honest concurrent use, which one sees in paragraph 69 to 70. The recognition of the existence of the defence of honest concurrent use. Which I think is recognised in the Daimler and Alavi case, which we don't have in the bundle, but also we see it in arising in the match and muzz-match decision, which very much focused on the trademark approach to honest concurrent use, but treated passing off, I think, with the agreement of the parties as essentially being at least there being a defence in passing off if there was a defence to the trademark claim. So there is a recognition that if you do have two separate goodwills standing alongside each other, that can be essentially provide a defence to passing on. And that, of course, that also arises, and match, I won't go into, but I ask perhaps you to look at it when writing the judgments, but it deals with the Budweiser litigation, where there was, of course, two separate businesses using using the Bud mark sitting alongside Budweiser mark. And although they weren't independent, they weren't connected at the beginning, they built up businesses which did have a level of confusion between them, and neither in the end could object to each other, and each was entitled to their own marks. And actually, I think I'll just take you also to, I will just take you to match and mustn't match, because it has a useful quotation from the ideal home case. This is in Bible.
Previous tower from Hammond Joyce.
Yes. So page 536. It starts at page 534. The IPC Media and Media 10. Judgments which Civil Justice Arnold sets out here. You'll see what happened there is there were two businesses using the ideal home, magazine business and show business. And they then came into contact in the area of online retailing. And there was significant levels of confusion, but neither could do anything about it. And so it recognises the fact that you can get this, what one might call an uncomfortable situation, but that can be the just outcome from the specific facts of the case.
So I wasn't keeping up properly. Which particular passage should I be noting?
So 536.
Yep.
You'll see, so it's a quote from paragraph 55.
Yes, I see.
So there are basically two parties who are the trade sources sitting there in the market. So that's what we say the proper analysis of the service agreement is. And if I could just move on then to deal quickly with the third ground of appeal and then my learned friends' points from yesterday.
Just before you do, you addressed this on the construction of the services agreement. Is that a complete answer to the judge's apparent finding of fact that there was a separate license agreement?
Well, my position on that is, first of all, not pleaded, and should have been, and therefore not open to the judge. And then, secondly, the reasons I've set out in my skeleton and have outlined, the factual basis for that, for making that finding, was insufficient. It's not sufficient. One couldn't rationally form the conclusion there was such an agreement on the basis of the materials available. And then thirdly, it is in fact inconsistent with the judge's own finding that goodwill was an asset, because then it actually does get dealt with in the services agreement.
I mean, one difficulty is you're, I think, impliedly recognising in that is that this court is slow to interfere with findings of fact. It will do so if a finding of fact can't rationally be supported. But it's difficult to go that far, isn't it?
Well, I think first point, obviously the pleading point is a different one. Not open on the pleading cases, and there's a reason why it shouldn't have been explored, because if not properly pleaded, one is not in a position to make appropriate factual findings. Parties haven't turned up to trial in order to establish that agreement, or prove it wasn't there. And then secondly, again, I accept, obviously, if it was open to the judge to make a factual then it is a high test for the court to depart from that. But then the third point, I think, is a separate one, which is if there's actually an inconsistency in his legal analysis. So on the one hand, he says he reaches a finding that it is dealt with within the agreement, which it requires that it be dealt with in the agreement. But on the other hand, he says that there's a separate agreement. Then I suppose one might properly analyse that as saying, well, even if there was a separate agreement, when one actually gets to the services agreement, that has replaced it, which is later, and then is obviously dealing with how people eventually ended up deciding for things to be done. That might be the proper way of looking at it.
Yeah.
So
You engage down three.
justification, this is dealt with from paragraph 109 of the judgment at page 189. The judge sets out a quote from the Sotterrock case and the EUIPO guidelines. And what I would draw attention to is, particularly in the EUIPO guidelines, the second paragraph recognises that if one's got direct consent, that can be a justification, and that we would say can arise from an agreement, from the proper construction of an agreement. And it also recognises exceptional reasons as being a foundation for justification. And then the judge, the crux of the judge's actual conclusions on this point is in paragraph 114. And he rejects our position essentially on the footing that we were wrong about the LLP having separate goodwill. He says it's only got a permissive right, and that's not enough. It doesn't have a right in the mark. Never acquired more than a license to use the mark. So he hasn't actually addressed, if you think that we're right on that, he hasn't addressed our basis for justification. And we say that here, where one has the two businesses alongside each other, that is a sufficient justification, because it means it's not like a case where an agent, what they're doing is essentially using the agency to get one over on the principal. It's a case where they are protecting a separate independent right which they have of their own, which is recognised under the relationship between the two parties. And I've come back to the point I think I mentioned yesterday, which is we say that there is no prejudice here because both can have marks. So if Quad wants to protect itself, it can get its own mark. LP can't use its trademark, obviously, against Quad during the services agreement, nor can it use it after that if Quad has its own trademark to protect itself, because Quad would then be entitled to cite its own mark. Use of one's own mark is a defence of trademark. So we say that there is no prejudice here, and in the odd circumstances where it's specifically contemplated, you have, at least after the very initial period, two businesses alongside each other, and potentially only the LLP standing, it's a justification for the LLP to protect itself, to get a mark which it needs potentially to protect itself against third parties now, for the continuance of the agreement, and which, if you said, well, it can never apply, and which would follow from the judge's conclusion, it would never be able to do that. During the life of the business, it could not get its own trademark in order to protect that part of the business, the LLP business. It would be entirely dependent on the wishes of Quad. And Quad might well say, well, And so that's why we say that justification here, in the unusual circumstances of this case, does provide an answer.
Can I get back to what you said about not prejudicing quad? I think what you said was that during the life of the agreement, LLP couldn't use its trademark against quad. That is because the services agreement recognised that what?
Well, and afterwards it can't. If quad gets its own mark.
What do you mean by if quad gets its own mark? You mean if quad registers?
If quad applies for a mark.
But suppose quad, I mean, the obvious mark for quad to register is quantum advisory, the word mark. But can it register that if it's already registered in your name?
It can. Yes, it can. We can't object to it, we say, under the agreement. So if they apply, we are not in a position. In fact, we would say further that we would be required to consent while the services agreement is in place. So actually, perhaps the parties have been loggerheads about too many things. So obviously one might think that a sensible course might be for that to have been the outcome. But anyway, we say that's relevant to the question of whether justification works. So if I could just move on now briefly to dealing with my friend's points from yesterday.
So we're on to the
Q,
quad appeal.
the hero Q.
Yep.
So first of all, and this was a point that the court picked up and which the judge based himself on, was there was no pleading of rights in ownership of rights in the Q alone. So one cannot then say, oh, well, we have the Q alone, therefore we get home, we own that mark, you're our agent, it's obviously the same, you have no justification. Obviously, if that was the case, if you get home at the beginning, then the same reasoning as the judge applied across subject to our appeal would apply to the hero Q. But we say that's not pleaded. And in fact, it needed to be pleaded because it doesn't follow that actually goodwill subsists in the Q alone. It's essential to making out a case based on a particular form of indicia that it actually be distinctive, that it be recognised by clients. Now, Q of a logo form in a sort of a rainbow may well not be distinctive to anyone. It may well not actually serve, particularly if other people use Qs out there. Q is hardly a rare form of symbol.
Can you really say that? I mean, register the mark for yourself?
Well, registering a mark does not imply that you actually own goodwill or something.
It's an assertion that the mark is distinctive.
It can be inherently distinctive. Taken by itself, it meets the threshold for trademark distinctiveness. But it doesn't necessarily mean that it's distinctive of us. Or certainly doesn't mean it's distinctive of Quad, which is actually the question they would have to establish. They'd have to say, well, we sent out umpteen letters to people. Obviously, it is used on some of the material sent out. What we don't know actually is how much a Q alone is ever sent out. Whether people see it as separate. So it's just simply not explored and is not a question where you can just assume there is only one answer to that. So that's the first point. And we say also it's not permissible to say, well, we can sort of get home by relying on equity in the actual trademark itself as the first step of the argument. First of all, if you've got there already.
Well, the actual trademark itself, you mean the registered trademark?
Yes, which I think my own friends seem to be suggesting, which is, well, equitable rights in the goodwill in the mark Q alone could be a foundation for a Section 10, could in principle be a foundation for Section 10B argument, concept of proprietor is a broad one. It's not limited to any particular method of owning a trademark right. In fact, you don't even need to own it in the United Kingdom. The primary reason for this clause is to do with marks owned abroad, where someone, an agent, has come in and snaffled it. Because if you didn't have business, you would have no goodwill in the UK. If you didn't have a UK-based business, you have no goodwill protectable in the UK, but your mark may be very famous. So that's the sort of the classic case aimed to be protected by the Paris Convention. But it's not limited to any particular form of ownership. But we'd accept that if you were the beneficiary of a trust by which the goodwill in the queue was owned. So if you had equitable ownership of the goodwill in the queue, that would be sufficient to get you essentially home.
But it's the equitable assignee, so you haven't affected your title, but you're entitled in equity.
So at trial, you might have to
Join the
you might have to do that.
No.
Possibly. But that's not the pleaded case. and as, for the reasons I said, the judge was right to say it hasn't been raised. My learned friend conceded yesterday that if it is just the queue, it's not similar to the mark quantum advisory. And she then sought to get from quantum advisory to the queue via a sort of bootstrapping type process where she said, well, we win against the marks which have the word quantum advisory but feature the queue, and they are similar, so there's sort of transfer of similarity. But we say that can't work, because actually what that's then doing is taking an aspect of those marks which, on the hypothesis of the pleading case, was not owned by the proprietor, was not owned by the claimant under Section 10b, and using that as a basis for then getting hold of that aspect in the supposedly objectionable mark. And so
Section 10b only requires you to be the proprietor of the mark. So why is it excluded?
Well, if they have the other marks, I'm not sure. Well, what I think what's certainly not pleaded is another pleading point. It certainly said, well, we own these marks by virtue of Section 10b, and then we rely on those as the foundation for our next Section 10b.
I understand that. Is there another reason why you can't apply the section iteratively, as it were? Get in some marks, but not ones which are not similar. But then once you've got those in, say that they are similar to the ones that you didn't get in on the previous cycle. Does that work?
Well, I would say it shouldn't work, because what it then does get you away from, it gets you away from protection of what the proprietor has an interest in protecting. So they have it has to be a prior right, first of all. So I suppose it doesn't, unless there's the right sort of sequence of coming into existence of the trademarks, registered trademarks, it wouldn't work anyway. But assume that there might be that right sequence, we'd still say that what one's getting away from is the purpose behind Section 10b, which is to protect what the proprietor, the skill and effort that the proprietor has put in from the abuse of the agent. And so if you're taking something which the agent has not derived in any way from the proprietor, that ought to fall outside the Section 10b protection. So that was that point. Then I think on similarity.
Just one more question. If they are entitled to rely on the marks that they gather in the first operation, accept all, well, I don't accept, but I take note of all the points that you make, that that's not open to them. Is the hero Q similar to any of the first three marks?
Well, I'd say we have to accept that it is.
Yeah.
The ones which actually feature the hero Q. As part of the mark.
That's very fair, thank you.
So I think on the facts of this case, though, none of that actually works, because the hero Q mark is in fact the earliest chronologically, and so if the other marks are sort of got home by basically purely on the basis of the registrations, saying, well, we should treat those registrations as having been made by Quad when they were made, they still fall after the application of the hero Q trademark. So the hero Q is the 28th of September 2018. And the next one's on the 9th of November. So it's not prior, and it's established that the right has to be prior.
Where does that come from?
Well, you can see it in the guidelines.
EU IPO guidelines,
UIP.
which we were looking at.
Tab 6 in bundle 1.
Oh, they're in the judgment.
ETMR is and we'd say it's implicit in any event from the actual statutory provisions. So you have to be the proprietor before the trademark is registered and made the proprietor of that mark. So,
And so I'm afraid I wasn't keeping up. Which page of the EU IPO guidelines?
Paragraph 1.
Paragraph 1.
Is, on page 1770. It's part of an earlier trade.
You said the Q mark was
3.2.
Yes, that's it.
Origin of the earlier mark. I think it's the cases as well. It's always been the case that someone turns up and says, well, actually, we built up this mark, and you've gone on taken it, rather than you've created it. Now, that might be a different case. You might have a different right to a mark you've created for someone else under a contract, which could potentially give you some kind of claim on a separate basis, but that's a different sort of claim.
Yeah.
So, I think probably I've said all I need to about that. The other cases, I don't think they have any real relevance given the concessions on both sides on the similarity point. So the John Mills case, we accept that similarity can be less than that implied by likelihood of confusion. But given the concession, you don't need to work out where the concessions, you don't need to work out where the boundary is. And the Sriban case of Mr. Justice Arnold, you then, well, again, that didn't establish anything. He didn't get into the question. He just said that, well, if it's sort of the same distinctive character, that's certainly good enough. Now, I think I should then turn on quickly to
just before we move away from that. You said the Q mark was the first mark. It was entered on the register in September, and then the one which has the Q mark and Quantum Advisory was entered in November. which is what you said, but they were both applied for on the same date. Does that make any difference?
Well, I'd say it makes, if that's the case, which, then it doesn't make a difference because it still means it's not prior.
Yes.
It's simultaneous, and it has to be prior. So it does require one to go looking at the non-registered rights, which we say isn't open to court, because obviously the mark was created quite a bit earlier and used, and so in principle goodwill could potentially be built up depending on the facts. But as I say, that's not what was pleaded, and so the judge didn't go into it, and you should not either. So then if I can move on quickly to the equity points, equity existing separately from section 10b. Now, we say that the Marussia case, although it clearly doesn't concern section 10b, is applicable by analogy. It sets out a principle, in essence, which is where the EU law has harmonised matters fully, there is no room for a separate national approach. And of course it is the case that sections 5 to 7, articles 5 to 7 of the directive, affect a complete harmonisation in relation to a different area of trademark law. But that of course doesn't preclude article 13 affecting a harmonisation in the area that it applies to. And so our argument, and which the judge accepted, is that well, this is an area where it's been harmonised. And when one looks at the case law, which my learned friend cited, the Salvador Benjunia Bravo de Laguna case, paragraphs 31 to 8 in file 2. That, in fact, supports our position, because what it says is outside the territory of the Article 18 of the regulation, which is the equivalent of Article 13, outside that territory, national law applies. But within the territory it's dealing with, it doesn't. And we say that here, it clearly is within the territory. This is a case where the Section 10b argument is being mounted, where it's accepted on this appeal. We've got to the stage where it's accepted that there is an agent or representative. And therefore, it does fall to be decided by the principles of Section 10b, and that there would be a different standards would be arising around the EU if it was free for a national court to the EU and the UK for a national court to apply its own national law to sort of add to the approach taken by Section 10b.
The way into Section 10b is the allegation that the claimant is the proprietor of a trademark. And I think you've accepted that that's a question of national law. If you have such a thing as a doctrine of equity, that can apply. You can prove that you're the proprietor of the mark in all sorts of ways. What the section then goes on to give you is a mechanism for transferring to you any improperly registered mark.
And a defence. So it's a substance, so the justification defence, for example, which arises.
Yeah, and also it says that you can, without being registered, you can sue the defendant for infringement of that mark, of the registered mark, which is probably the only instance where that can happen. But in order to get in at the front end and show you're the proprietor, why is it not open to you to rely on doctrines of equity?
It is.
Yeah.
We accept it is.
Yeah, including these marks were registered in breach of a fiduciary duty.
Yes, I think that's correct. Yeah.
And so they can get home, can't they, by saying all 4 marks are registered in breach of fiduciary duty, and we're the proprietor of those marks, and then operate Section 10B. And you're not excluding Section 10B or using equity to mess about with 10B. You are simply applying 10B by the letter.
Yes, I think I'm not sure that's correct. I think that once you've got to that stage,
What you're dealing with now is an argument that says forget all about Section 10B.
We'll just look at it in equity
and gather in the marks in equity and don't use it at all. And that, speaking for myself, I can see the force of the argument that would be to give a different regime in the UK to that which applies in other member states.
Yes, I think we accept that. What you just said. So I think I should briefly comment on the position on European law and its continuing applicability. Now, you may have had a chance to read my own friend's supplemental skeleton argument. Our position is that the transitional provision is not exactly the clearest as to what it means. You apply the provisions of Royler do not apply to anything occurring before the 1st of January 2024. Now one could see that perhaps if the court's applying provision now, so if it was considering an assignment, which is something you can obviously go for rather than rectification, that might be something which you regard as occurring now. But in any event, our position is it doesn't make any difference on the facts of this case. We think probably the correct position is it doesn't apply to this case at all. But in any event, it won't actually alter the position as to how one should approach the provisions. You may be glad not to have that particular position. Let me just check if there's behind me whether there's anything else. So unless I can assist you any further.
Thank you very much, Mr. Hill, and you're impressively nearly on time, despite the time lost earlier. Mr. Adams.
Thank you, Sir Lordship. If I can start off by just saying, in brief terms, what we say the correct analysis is. Firstly, Quad and its predecessor owned Quad, which are both companies, or were both companies, with separate legal personality, and therefore could generally only act through agents, have at all material times carried on business as providers of consulting, actuarial, administrative and investment services under the name Quantum Advisory and its associated banding, building up a goodwill associated with that name and branding. Since April 2007, second point, that business has in fact been carried on through the agency of LLP. That relationship, which was established in April, was regulated by the services agreement entered into in November with effect from April. LLP, fourthly, owes a duty to Quad, a fiduciary duty to Quad, because it is undertaken to act for and on behalf of Quad in circumstances which give rise to a relationship of trust and confidence. I think that appears to now be accepted. As a result, LLP must not profit out of their trust and must not place itself in a position in which its duty and interest, and I emphasize the word may conflict. Sixthly, the equitable rule, which is the modern way of putting it, is that the LLP is on the face of it to be treated as having acted for Quad and to have acquired any benefit for Quad, where to claim it for itself might give rise to a realistic possibility of a conflict between its interests and those of Quad. Or in old language, is stopped from asserting otherwise unless it can justify what it has done is for its own benefit by proving either one, the burden of proof is on it, one, that what it did was unrelated to and independent of their fiduciary position, or two, that it had Quad's full, free and informed consent to do it for their own benefit. And the consequence of that is that Quad has a proprietary remedy in respect of any property acquired in the course of carrying on Quad's business, unless LLP can prove Quad's full, free and informed consent to obtaining such a benefit for itself. Hence, in this conclusion, LLP's case on appeal has to be, if it is to succeed, that on the proper construction of the services agreement, to which Quad admittedly gave its full, free and informed consent, LLP was entitled, as of right, to carry on its own business under the Quantum Advisory name and brand in all circumstances which might, and I emphasize might, arise, including in the event that the services agreement is or had already been terminated, so as to be entitled to register the trademarks for its own sole benefit. Otherwise, the equitable rule is that the rebrands are treated as having been done on behalf of Quad, and the trademarks were obtained for Quad's benefit. Or in other words, LLP is stopped from asserting otherwise. Mr. Hill firstly says that LLP was entitled under the services agreement to carry on business under the name. That's the point of construction. And as I've just mentioned, you will have to do that in all for the purpose of all circumstances. Mr. Hill secondly says that LLP did, well, he was saying we didn't owe any fiduciary duty. I think he's moved away from that. Mr. Hill, in the course of his earlier submission, suggested that LLP isn't acting for Quad's, doesn't act deal with Quad's clients. I think, if I'm right in thinking, he's moving away from that position now. Perhaps I better deal with it. In the written submissions, Mr. Hill said he did not, that LLP did not owe any fiduciary or like duties. So there are neither any applicable electoral consideration, nor does Section 10B have any application, as LLP cannot be taken to be enacting as Quad's agent or representative. And he says that primarily as a matter of construction. But as I had understood his case, he did not deny that the Quad in fact acts as LLP's agent, in particular undertaking all its dealings with its clients on its behalf, which includes agreeing fees for work undertaken. Mr. Hill suggested that LLP no longer has contractual dealings with Quads on a client day-to-day basis. It has, however, been common ground in this and other proceedings that they do. And generally, there's an annual fee and then ad hoc work done for individual clients. And there were agreements to that effect before the court in one of the other actions last year.
I mean, I assume we're going to come back to all these points.
My Lord, yes. And thirdly, Mr. Hill says that he's built up an independent goodwill concurrently which he can rely upon. I'm going to deal with the first 2 points, the pleading point that arises in the third point, and Ms. Himsworth King's Counsel will deal with the balance of the argument.
And I'm so sorry, I haven't got clear. So the first 2 points are...
First 2 points are whether on the construction of the services agreement they've been granted the right to use the name. Secondly, does LLP owe any fiduciary or like duties? Thirdly, has LLP built up an independent concurrent goodwill which it can rely on?
Yes, I see.
And that third point has both a pleading point and a trademark point. My learned friend Ms. Himsworth will deal with all the trademark aspects. And I'm going to start, I therefore start with the construction of the services agreement. And we'll move on to the nature of the relationship which the services agreement establishes. And we say, I think probably 112 of our skeleton, that the judge correctly found that the services agreement only regulated the conduct of the legacy business on behalf of Quad by LLP. That's paragraph 53 of the judge's judgment at A16, tab 13, A16. Your Lordships, I imagine, are very familiar with the judgment. I don't propose to take your Lordships to it now unless it would be of assistance. But it followed that any use of the mark by LLP for its own business was necessarily permissive unless LLP could prove some other lawful basis for its use. And that is why LLP accepted at the outset that it needed our permission and has to assert that now such permission is no longer required. That's paragraph 14 of the defence at supplemental bubble tab 3B17. And I think it's accepted in Quad's skeleton at paragraph 48.3. Quad, of course, had the ability at the outset to prevent use by LLP of legal means, by legal means. And, my Lord, the fundamental point is that, as I've already mentioned, that for LLP to succeed, it must prove that it was granted the right to use the name under the services agreement. My Lord, just pausing there is a difference between goodwill, which attaches to a business, and can only be realised, only ever its economic value realised. It has no tangible existence. And the use of a name, which can be licensed or permitted to be used by somebody else. And what we're concerned with is the right to use the name. And the point is very well illustrated by, I think, one of the last cases my learned friend took your lordships to, which is the Hayman Joyce property, which is Authorities Bundle tab 26, page 543 of the bundle. My lord, as my learned friend explained, there was a pre-existing business carried on by Mr. Hayman Joyce in his own name. He then entered into partnership with another to open a new branch in an adjoining area. I think there were two separate areas and one area they were both to work. And under the partnership agreement, it was agreed that Mr. Hayman Joyce and his partners would carry on business under his name. And the dispute was whether the partnership only had a revocable license to use the name or had been granted the right to use the name. And turning up the case, my learned friend, just in passing, took your lordships to the passage at paragraph 31, where dawning day is discussed. And I think your lordships picked up the observation that such goodwill may have evolved independently or devolved from a common ancestor when several businesses use the same name to acquire goodwill. And that's, of course, the question. Starting at 36, Mr. Amanda Michaels analyses the partnership agreement and in particular noted that there were provisions in the partnership agreement that the name could, as of right, be continued to be used by the partnership in the event that Mr. Hayman Joyce left the partnership, and it was only if the partnership was dissolved in certain circumstances which were not anticipated that all the partners would have to stop using the name. So potentially for the foreseeable future or indefinitely, the partnership was entitled under the partnership agreement to use the name, and was there, and it was for that reason that the conclusion was, constraining the agreement as a whole at 46, it's halfway through, or two-thirds of the way through 46, the conclusion is that all the circumstances governed by clause 20, the right to use the name of the business asset, which could be acquired and used even after dissolution by a continuing partner. And it was for that reason that the new business was entitled to build up goodwill in the name. And at 45, I think my learned friend draw your lordship's attention to the point that it would have been different if there hadn't been such a grant of the right to use the name, rather than the implied license would probably have been only so long as the two businesses were associated, as in our case. Now, before turning to the service agreement, I just want to make a couple of further points on the facts and the context of it. Mr. Hill, in his skeleton at paragraph 7, has said, and repeated in submissions, that the primary purpose of the agreement was to facilitate Quad's replacement in the actual aerial business of LLP. That this was over a protracted period required because LLP was not in a position to buy Quad out, and he uses the words all at once. And he says that Quad's business was inevitably expected to erode away to nothing. But the judge, by reference to his earlier judgment, dealt with commercial purpose at paragraph 74 of his judgment. And that's core bundle, tab 13, page 175. And the judge in 74, Mr. Hiller's submission had been that the commercial purpose of the arrangements was to enable LLP to develop its own business. But he then says, he cites from his earlier judgment that it was a bespoke agreement fashioned to address the competing needs and interests of a group of professional people, and in particular the practical issues involved in permitting one part of the group to enjoy the benefits of the established quantum brand of business when they were unable to afford to buy out the interest of the other part of the group. And the benefit to the new entity was that it would receive a turnkey business, would take over all the staff and of the legacy companies, have full use of their premises and equipment and the quantum brand, as well as having an established client base on which to build a new business. Thus, it would be enabled to develop its own business without the usual costs and associated risks from starting a business from scratch. And my lord, that's a pithy summary of the findings in the first action. If one turns up tab 7 in the authorities bundle for just a couple of other pages in the first judgment of His Honour Judge Keyser, which I draw your lordship's attention to. If one goes to page 134 in the authorities bundle, paragraph 93 of the judgment, there's a lined passage at the beginning of the judgment which sets out the background in summary form. 93.1, again, the judge mentions the context of the agreement being the springboard for LLP was provided in the form of financial assistance, and in fact Quad, as your lordships may have seen from the services agreement, advanced LLP £250,000 as working capital. The use of the means to carry on business and the ability to carry out the legacy business and use the quantum brand. But the legacy business itself, its goodwill and its profits, was not given to LLP, but remained Quad's. Pausing there, if one looks at the evidence of Mr. Baldwin, it was important that there was no transfer of goodwill for tax reasons as well. The LLP never bargained for its acquisition, and the express services agreement expressly advised it for it to revert upon termination of the agreement. 4, a basic point of the service agreement was to enable the members of the LLP to use the legacy business as infrastructure in the quantum brand to build up a business of its own, while at the same time the legacy business remained that of Quad as mentioned above. At 139, perhaps over the page 135, just the end of paragraph 93, this was in the context of the restricted covenants. The covenants give effect to the ownership boundaries, and they reflect the fact that while the LLP is given the benefit of servicing the legacy quantum business for the length of the period it agreed to, and therefore wanted, it has not acquired the business for itself, and is not entitled to use its favourable position on the services agreement to help it take a business for which it has not bargained. And the reference there to ownership boundaries appears elsewhere in the judgment. But this was the drawing the ring fencing of Quad's business, which was its existing clients, the clients it expected to get in the year after the services agreement took effect, and new business that effectively flowed from that existing business. So as companies expanded and got bought subsidiaries, for instance, with pension schemes, then they might come into the fold, etc. And in fact, I think that the turnover has increased. At paragraph 105, on page 139, there's a lengthy consideration of the term and the complaint that the 99-year term meant the covenants were unreasonable. But there is a finding halfway down 139, I think just below there's 100 in square brackets, and then just a few lines below that. Again, the 99-year term is not arbitrarily long when viewed in its context, rather than in comparison with wholly dissimilar contracts. The client for whose benefit the services are to be provided are pension funds, which may themselves exist for more than 100 years, and might therefore remain within the scope of the services agreement for that time. So there was an express finding in the first action that the services agreement might subsist for its full term. And therefore, on the second, it's wrong for my learned friend to suggest that the purpose was replacement in the actuarial business by LLP. Rather, it was to ring-fence Quant's existing business and facilitate LLP to start a new business. It's also wrong that the business would inevitably road to nothing, and is contrary to the judge's earlier findings, even if the parties subjectively considered it might diminish over time. Mr. Hill makes much of his windfall argument, as I understand it, as relevant commercial context for his construction arguments, namely that LLP may yet have commercial reasons to buy the goodwill, which he maintains would be a windfall to Quad, even though it was unable to buy it in the first place. What it should be noted in this context is LLP always had a choice, and continues to have a choice, as to what brand it trades under. It decided to trade under Traders Quantum Advisory in full knowledge that any investment in the brand might accrue to Quad in the event of termination of the agreement. And His Honour Judge Keyser recorded that at paragraph 60 and 61 of his judgment. That's core bundle A168. Tab 13.
61, 62, did you say?
Sorry, A168, paragraph 60 and 61. And your lordships might just read what was the passage from Mr. Reed Jones' email that was set out in the judgment, because that shows that in March 2007, LLP were acutely aware, when they were discussing whether or not to use the Quantum Advisory name, as to what the consequences would be. It's presumably traded as Quantum Advisory because it is profitable for it to do so, and continues to trade under the name because it is a continuing value to it to do so. But given it could rebrand at any time, it's not obvious how it could be held to ransom. If the opportunity ever arises for LLP to buy the brand, then it will be a commercial decision for it in the circumstances, given the relative bargaining positions of the parties, as to whether a price can be negotiated for it. And with those matters in mind, one can turn to the services agreement, because we say the judge was quite right. This is all to do with Quad's business and nothing to do with LLPs. We say on its face, I know some doubt was expressed in earlier cases as to whether it was an agency, but we say on its face it is obviously an agency arrangement.
Just to be clear, what do you mean by that?
Well, I mean in the Pengelly sense of a fiduciary relationship where one party is authorised to deal with another's affairs.
And just exploring it a moment further, in a strict sense, agency refers to an ability to change somebody else's legal relationships. Is that suggested here?
Well, my lord, we understood that to be being suggested in the defence, why the slightly odd pleading in the reply. But Bousted, I think, there's a passage on this in Bousted. I think the current view is that that agency is effectively synonymous with a fiduciary relationship. An agent may be instructed to do things where a fiduciary relationship doesn't arise, but if an agent is to do anything on behalf of another, then that is effectively synonymous with my lord, the passage I have in mind.
Just before you go there, can I break it down? I mean, there's a general recognition that agents are in a fiduciary relationship with their principals. On a very strict view, an agent is somebody who has an ability to change the principal's legal position. Is that said to be the case here? Is it said that LLP has or had the ability to change Quad's position?
Yes.
Yes.
Yes, absolutely.
And more specifically, is it said that LLP has an ability to cause Quad to enter into contracts?
Yes.
Yeah.
And but in any event, I think the way it's put more recently in the case is the ability to affect your legal relationships with third parties, and everything LLP does has the potential to affect our legal relations liability, for instance, which is why it, and a good example of it entering into legal relations on our behalf is that it is required to maintain professional indemnity insurance. Under the services agreement, it has to arrange the professional indemnity insurance and deal with all claims made against Quad. And it's a fairly obvious example of where it's both contracting with third parties and dealing with third parties in legal matters. Might be dealing with might be giving instructions in legal proceedings on our behalf. But we say in any event, on the face of the agreement, it was given the necessary power and authority to deal with our clients. There's a carve out for new tendering, but otherwise all day-to-day dealings with clients are in fact carried out by Quad, and we say carried out by LLP, and we say LLP was required to do so under the services agreement. And if one starts page...
Just before you do, on retendering, I'm afraid I haven't paid attention to the previous decision. So suppose you're in a trustees meeting and the trustees say, well, we better have, as my lord suggested, a further valuation, or the trustees say, well, we better have advice on GMP equalisation, which has been a vexed topic. Is that a matter for retendering? How does that work?
No. I think, it's quite difficult to draw the line between retendering and what is and is not retendering, which is partly what the argument was about in the Court of Appeal, because there can be a sort of salami slicing attempt. But I think it was common ground. It was certainly common ground. There was another case before His Honour Judge John, which is not in the bundle last year, about what information, access to information LLP has to give to us. And it was certainly, there was evidence there that generally engagements do precisely that. They allow for both regular work and ad hoc work. We are never in those meetings. It will be LLP in those meetings. They will agree to do bits of work for a client, and they will contract on our behalf to do so. By law, that's entirely consistent, we say, with the terms on the face of the agreement.
What about clause 8.1?
Well, my lord, 8.1.1 it has caused a number of difficulties. Can I get to 8.1.1 from the start? Because one starts at the recital.
You'll explain why it's consistent when you get to it.
Yes. Well, the recital is, and by clause 1.8, the recital is an operative provision. Quad has resolved to appoint, the language of agency, the LLP, to carry out certain responsibilities for and on behalf of, which is again the language of agency, Quad in relation to its business. And the LLP agrees to carry out such responsibilities, the services defined below, in consideration for the payment by Quad of the administration fees and other payments due to Quad pursuant to this agreement. While we're there, assets means those assets in Schedule 1. Schedule 1 means all assets owned or leased by Quad, this is page 228, to the extent they are used, and I emphasise the word used, because we do maintain you can't use goodwill, on or prior to the date of this agreement, for the provision of services to the clients or for any reason relating to the business of Quad.
So your case is that goodwill is not an asset as defined.
Yes, we have maintained that on appeal. Over the page, one has the extended definition of clients, which must be read with the definition of pipeline business and prospects on page 205. Precise terms are not important for our purposes. The effective date on page 204, 6th of April 2007. Information means all data, records, files, or information in the possession of the LLP in relation to clients and services. And the initial period is 99 years. And as the judge noted, bottom of page A205, it was anticipated that Quad might have to replace LLP if the services agreement was terminated, and so there's a replacement provider is defined as somebody who provides replacement services, which are defined as services which are identical or substantially similar to the services, and which Quad receives in substitution for any services following the termination or expiry of this agreement. The appointment clause is then 2.1. With effect from the effective date, Quad confirms the appointment of LLP to be subject to the provisions of clause 2.8 below, which is to do with certain things still being done by Martin Coombs or Martin Coombs Company Innovation for an initial period. To be solely responsible for the provision to Quad of the services set out in Schedule 7, to the extent that they relate to engagements and pipeline business, that's the ring fencing. Together with such other services, the parties may agree from time to time in writing that LLP is to perform the Quad. As I think my learned friend alluded to, LLP has developed new services, and with Quad's agreement, those have been offered to Quad's clients as well as LLPs. And then the last sentence, Quad confers upon and grants to LLP such power and authority as is necessary or desirable for providing the services. And that will include, and if one looks briefly at Schedule 7, which is at page 238, the first heading is the provision of services to the clients. Provision of pensions, consulting actuaries, administering investment services, including by way of example, and all the sorts of things you do in the ordinary course of providing such services to clients. Didn't include taxation work, because that was what innovation was going to do. And then there are headings for Quad administration, which includes such administrative support as Quad may reasonably require from time to time, and the handling of preparing professional indemnity proposal form and dealing with any actions against Quad, including the notification of any actual potential claims of professional indemnity insurers. So on the face of 2.1, LLP is expressly granted authority to do everything that's necessary to provide the services. I think one can then go on to 7.1, A213. Quad shall provide the services to Quad subject to the terms and conditions set out in this agreement. Sometimes the languages provide services to Quad, the use of the language in relation to services on the construction the Court of Appeal has already given to the services agreement is acknowledged to be somewhat inconsistent. Sometimes it's referring to services, generally it's referring to services provided to clients, but in other circumstances it's given a broader meaning.
I mean, I suppose there may be no difference between the two in some sense. I mean, if you are providing the service to a quad client, you might be said to providing it to quad.
Well, my lord, I think well, precisely, I think the judge has made that point in his judgment. You're both providing the services for quad and providing them to quad. But
Can I just be sure I understand that? Take a typical case where trustees of a defined benefit scheme need a triennial valuation. It needs to be done by the actuary. If it's a legacy client, contractually it's quad that provides the valuation. But the person who actually does it is the scheme actuary, who will be an employee of LLP, provides the work to the client, and in doing that is fulfilling quad's contractual obligation to do the valuation. And in that sense is providing the valuation to the client on behalf of quad, but at the same time is doing the valuation for quad, so is providing a service to quad of doing its valuation.
Precisely.
Is there any dispute about that? Because that seems to me to be fairly apparent.
It was argued. It was previously argued in the first case and subsequently that LLP sought to argue that it was just a subcontractor, and that meant, in some sense, it didn't do anything on our behalf for our clients. But I don't. That cannot any longer be sustained because there are ample findings to the contrary, including by the judge in this case.
But obviously when it's handling professional indemnity claims from the client, it's not doing things for the client, it's doing things for you.
Yes, absolutely. But it is still dealing. When it settles that claim, it's doing it for us.
And just to be clear, do you think it is clear that LLP can actually settle the claim?
Yes.
So that would depend on the construction of the last heading at
Well, perhaps it doesn't.
A238 in Schedule 7. It says dealing with any actions. That's not necessarily the same as settling one.
Well, dealing with to a conclusion. It is. Including notification of potential claim. And there's also there's a provision. I think there's an express provision in the which we haven't got to yet, which does deal with professional negligence claims.
I see. Okay.
It's well, 12.1 provides it must arrange the insurance. But my lord, if it needs to be decided, it is certainly Quad's case that LLP has authority, and I suspect I think has done in practice, is to deal with any claims full stop.
And just picking up your point on professional indemnity insurance, leaving aside the settling of claims, that requires LLP to effect and maintain professional indemnity insurance, which on the face of it does involve entering into a contract on Quad's behalf.
Yes. My lord, 7.3 is the clause that my lord if I particularly relied upon, suggesting it set a standard
just before you go to 7.3, 7.2 is the one that says that Quad will make available the assets to LLP.
Oh, sorry,
Are you? Mr. Hill says, well, actually, the judge is right. Assets includes goodwill. You say no, that's wrong.
We say two things. A, assets is not, goodwill is not an asset that can be used. And my lord, I was going to return to this point, but in essence, what we say is that Quad trades under Quantum Advisory name and brand. Everything, and by doing so, generates goodwill. That goodwill increases the value of its business. It is an attractive force which increases the value of its business. It can use the name, it can use perhaps premises.
Meaning LLP can use the name.
Or Quad.
Oh, sorry, Quad can use the name.
Quad, when everything, it is, because it's Quad's business, it is Quad's using its name. When LLP does something in its name, it does so on behalf of Quad. It is Quad using it.
So you say there's nothing in this agreement that gives LLP the right to use the name on behalf of Quad.
Well, it uses the name on behalf of Quad because it is acting on our behalf. But that's not a. It's wrong to characterise the name as an asset, at least until it becomes an object of property as a trademark.
So to be clear, I assume you're saying on that basis there doesn't need to be anything in this agreement giving LLP the right to use the name, but it is your case that there's nothing in the agreement giving LLP the right to use the name even when dealing with the legacy business.
No, it clearly has the right to use the name. It's not I think this is perhaps terminology, because when an employee, you wouldn't necessarily, if McDonald's employs somebody to serve a burger, and they say, we're charging this much, the employee may use the name, but he's not granted any right to use the name. He's just doing so on behalf of his employer.
So it is the case that you say there doesn't need to be anything in this agreement granting the right, but it is also the case that you say there is nothing in the agreement granting the right.
Yes, there's no grant of a right to use the name. It is necessary to use the name to carry on our business for us. So it's obviously permitted for employees of LLP to utter our name and generate documents with it on. And
where do they derive where does LLP derive that right from?
Well, there's a difference in a right and a right, as in the Heyman-Joyce type right, is a grant to be entitled to use something in your own right. LLP never uses our name in its own right under this agreement.
But isn't that true of all the assets that are made available under 7.2? It's using them to provide the services for you. So that doesn't seem to provide a clear distinction.
Except there's no property in a name. I think that is the distinction. In English law, there is no property in the name, and it is not something that it can be attached. I can use it for my business.
You can license
But
it.
I can license it to another as long as as long as it's not a license in gross, so they're not making a deceptive representation by doing so. But I can lawfully allow somebody to represent themselves as associated with my business, yes, and I can earn a fee for that, and I am therefore dealing with, in those circumstances, you're authorising somebody to use your name in their own right, and so you are actually granting, as in Hayman Joyce, or agreeing to somebody using the name in their own right for their own purposes. But that's different from somebody doing something on the principle on your behalf using your name, because when they do it, it is you that's doing it by their agency, not them in their own right. Does that make sense?
I'm not sure it really matters that much, but I'm not sure I do follow what you're saying.
Well, my lord, if an ordinary employee in a business is not granted under his contract of employment any right to use his employer's name. He is employed in the business, so he uses the name, but everything he does on behalf of the employer. So in those circumstances, it is the employer using the name in its own business, and maybe acquiring goodwill by using it through the agency of its employee. But for its employee to use the name on its behalf, it doesn't need to grant, say, some implied permission to use the name. It doesn't grant the right to the employee to use it in any other
circumstances. We're getting into trouble by talking about grant of rights. Grant of right occurs when you have an assignment of the mark or goodwill.
Yes.
What we're talking about here is permission, isn't it?
Yes. But there is, if you have a contractual license which sets out terms on which you're entitled to use the name, or like in Hayman Joyce, you have a partnership agreement that sets out the terms on which you're entitled to use the name, then as in Hayman Joyce, it could be used indefinitely. It was held that was in the right, it was being used in the right of the partnership, not in the right of Mr. Hayman Joyce.
Right.
Whereas whenever the name is used in our business, it's in our right.
So your point is, you do permit them to use your name, but that's necessarily implicit in them acting for you in the way the services agreement. But it's also implicit when they're no longer acting for you, they don't have the right to use your name in your business because they have no right to represent you anymore at all.
Yes.
But yes, it doesn't really deal with using the marks in their business.
No, because
that's a separate point.
Well, that's the separate point. The judge, we say the judge is right on that. This agreement's got nothing to do with their business. This is all to do with ours. And therefore, so what we make available is everything that can be used: the desks, the computers, the computer programs, the yes. My learning friend says the website, which is and so that's the first point, is that it's not an asset. The name itself is not an asset used in the business. And
it's not really a proper question, but I'm not entirely following why you are so resistant to the idea that it's an asset. It sounds as if Mr. illustrates his position, but since the trial,
Well,
what
my
will
lord,
actually help you if it's an asset?
my lord, in my submission there are 2 points. The second point is that there is a license to use it under 7.2, which terminates immediately upon termination of the expiration of the agreement.
Yeah, that's a clearer point.
So my lord, that's the stronger point, and perhaps I'm dancing on a pinhead on the first point. But the pinhead I'm trying to dance on is the nature of there's no property in the name. The association with the name creates goodwill, but goodwill is not a tangible asset which could be used. It could be realised economically, but cannot actually be used. And my lord, the second point is that this license, which is not my learned friend tried to use his context to say, well, actually, that's not what it says. It's the reverse of what it says. Our argument is quite simply, it is what it says. Enable it to perform the services and to be terminated upon the expiration of this agreement, which makes perfect commercial sense.
So the services are the services for you.
Yes. Nothing more and nothing less. That's the judgment.
And so this doesn't of itself provide any authority, whatever you think about the meaning of assets, to LLP to use the name in its own business.
No, exactly. And while we're on the point, one can also look at Schedule 9, because my learned friend tries to work backwards from Schedule 9 to say trademark is what's defined as a non-exclusive asset under Schedule 9. But Schedule 9 has its own definition of assets, which excludes quad assets. That's the top of page 248. So this is Schedule 9 is only dealing with LLP's assets.
But is quads assets a defined term, or is that?
Well,
it goes back.
assets is the defined term in the main body of the agreement.
I mean, it fits together if clause 7.2 says quad makes available its assets, but on the basis that they go back on termination. If, on the other hand, other assets are used by LLP in connection with the provision of services, then you're into the exit plan scheme.
And I know while one's on the exit plan, it might be worth noting 5.12c on page A252. Upon the LLP shall return to quad such that the following is in LLP's possession or control. All materials created by the LLP under this agreement, the IPRs in which are owned by quad. So it clearly anticipates that LLP will be doing things on behalf of quad which generate intellectual property rights that may remain in their possession or control, and they've got to be delivered up.
So, anything in which copyright subsists,
Yes.
any inventions, design.
My lord, if I can just draw your. I think I wish to sort of develop one, if I've got time, one or two of these points in due course. 7.3.214. This is, as your lordships have pointed out, this does not prevent LLP being a fiduciary. Everything they do for us, they exercise their own discretion how they decide to do it, and when they do it, they must be loyal to our interests. And again, 7.5 is without generality to LLP's obligations contained in this agreement. And what that says is that that reinforces the boundary between the two businesses and ensures that they're both carried on to a similar standard. That does not mean that when LLP is carrying on our business, it does not have to be loyal to our interests. Just as the fact that it has a discretion as to how much time and effort it devotes to the efficient operation of our business is a matter for them. We trust them to devote the time that's reasonably necessary. But when they're in deciding how much time to spend, they must be loyal to our interests.
I'm not quite sure about that last bit, but it really doesn't matter.
No.
I mean, you are impliedly saying that where there is a fiduciary relationship, you have a duty to devote the time needed in the other person's interests, as I understand it. Well, that isn't necessarily clear from the learning of fiduciary relationships. That's different.
No, I think the point was against it. It was because the point that was made against us was that because LLP has discretion how much time to spend on our business, that means it's not a fiduciary. But those are sort of achieved sort of concepts. Then, to a certain extent, I was drawing the Lordship's attention to the other clauses we came through because we were heading for 8.1 or on 214. And the language of this is not straightforward because on its, with the fact from the effective date, the subject to provisos of this clause, and clause 8.3 below, LLP is authorised to and agrees to exercise the powers and authorities conferred upon Quad. Now, on the face of it, the powers and authorities conferred upon Quad are not Quad's own power and authority deriving from its own capacity. And one possible construction of this is that all this is referring to are powers and authorities that are granted to Quad, as may well be.
It must be a misprint for LLP, isn't it?
Well, it's either a misprint. There are two possibilities. One, it's a misprint from LLP, or it is only dealing with the sort of things that may well be granted under an engagement to make investments or to do things on behalf of a client, keep a payroll, or keep them. So there'll be things under an engagement which Quad is authorised by its clients to do on the client's behalf. It may just be dealing with those powers. Alternatively, Quad is a misprint for LLP to the extent that such powers and authorities relate or are ancillary to or rise or are requisite for the provision of services, provided that the duties and exercise of the powers and authorities referred to in this clause shall have no power or authority whatsoever to bind or commit Quad, other than pursuant to power or attorney or other written authority granted by Quad. And on one view, what the rest of this agreement does is authorise expressly in 2.1 Quad to do everything that's necessary to provide the services. So what this may be aimed at is anything that's not within the ordinary course.
Certainly, if you take your professional indemnity insurance example, it's envisaged that LLP will effect the insurance, thus entering into a contract for the benefit of Quad. It would be quite odd, given that express provision, if LLP had to seek express approval for that under 8.1. One answer is, well, look, clause 12.1 gives authority in writing for that.
Or the other way of looking at it is this has got to be construed with the rest of the agreement. And 2.1 gives express authority to do everything necessary to provide the services. And 12.1 provides authority to arrange the professional indemnity insurance. And they must be read as against with 8.1. And even if Quad is a misprint for LLP, then the other authority granted by the services agreement must be within the meaning of written authority granted by Quad. And it is on the face of it within the meaning, it is written authority. Unless the only other construction would be to those other provisions are effectively surplusage and included by mistake and wholly excluded by 8.1, which, as your lordship says, would be a nonsense construction.
Suppose it's not a misprint for LLP. Suppose it's intended to refer to powers and authorities conferred upon Quad by clients. What sort of things might be encompassed within that?
Well, I suppose clients might authorise. Clients under engagements. Quad, for instance, undertakes the administration of pension schemes for pension trustees. In the administration of that pension scheme, they will have to do all sorts of things: investing assets, dealing with members.
I'm looking at Schedule 7. So it's pensions administration, record keeping, benefit calculations, member communications, that sort of thing.
Yes, that would all be done on behalf of the client, with the client's authority under the engagement. And if it's in fact being done by LLP, then this is an authorization from Quad to LLP to a sub-authority, effectively, to do all those things that Quad has been authorized to do itself. Well, the basic point for our purposes is that 8.1 does not prevent this contract being an agency. And what it certainly doesn't do, and the judge is right, is give any authority to LLP to use its goodwill insofar as that is possible, or even its name and branding in LLP's own business. It is anticipated, one can see from the terms of this agreement, it's anticipated that LLP will have a similar business to Quad. But that's as far as it goes. And we say that Quad's claim and appeal is misconceived insofar as it's based on an entitlement to be found in the services agreement. And for the same reason, the LLP's reliance on paragraph 44 of its skeleton argument on the entire agreement clause is also misconceived. My Lord, that, unless your Lordships have any further questions on the construction of the agreement, brings me on to fiduciary obligations.
Does it take you to fiduciary obligations? Do you not have to deal first, or are you dealing with it at some other point, with the challenge to the judge's finding as the external license?
Well, my Lord, that comes third in my submission.
Does it?
That is, my Lord, I will do it. It's a matter of fact. There's ample evidence for it. If your Lordship just wants to refresh your Lordship in the 10 minutes before lunch, it might be worth just refreshing your Lordship's refreshing your.
Just tell me why it comes third. I would have thought it was an aspect of the basis on which LLP was authorised to.
My Lord, it comes third because the difference between the parties, and in my submission it can only be understood in the context of a fiduciary relationship, is the difference between the parties is my learned friend says it is for us to plead and prove a contractual requirement for them to stop using the agreement, using the name, whereas we say it is for him to prove a contractual entitlement that he's entitled to use the name.
And I see the debate, but I'm not quite sure why this has anything much to do with fiduciary duties. Forget about fiduciary duties for a moment. If you start with Quad owning, having the goodwill, being entitled to use the name, and then proceed to a point where LLP is doing things for Quad, one way in which LLP can be entitled to do that is pursuant to the services agreement. Another way is pursuant to some external agreement. I don't know where fiduciary duties come into that.
Because our case is that a permission, a license, is something that's done unilaterally by the person who gives it. They authorise somebody to do something which would otherwise be unlawful.
Well, that's
and the judge has found, as a matter of fact, what the scope of the license we gave was.
yes.
And so, but my learned friend says no. Once I have your license, unless you can point to a contractual term that stops me using it for my own benefit, other than independently of the license, I can build up an independent goodwill. That is his case, and that does turn on whether or not it's our fiduciary.
Well, by all means, take matters your own way. I'm not sure that anything in the judge's reasoning relating to licensing says anything about fiduciary relationships.
No, he said he found, as a matter, he asked himself the right question: what was the scope and terms of the permission that was granted? Because we say, if you're using our name and brand with our permission, then you cannot be building up your own independent right in it. It comes back to us.
I'm not sure the judge quite says that. He simply says, well, was a right to use the name granted in circumstances where Quad starts off with the goodwill? And he says no, because it's not in the services agreement and it's not in the parallel license that must have existed. And that doesn't seem to have anything much to do with fiduciary duties.
Well,
anyway, take your
my answer to my learned friend's suggestion that it has to be that we, to stop him using it, we have to point to a contractual term that compels him to stop using it. It does depend on the relationship between us. It does depend on fiduciary duty in my submission. I'll try and take it shortly because it is now accepted that we are a fiduciary.
I'm not sure that. Don't remember Mr. Hill accepting that. So I think you best say what you need to say.
Well, my lord, I better say. I thought in his final submissions he did accept that we were fiduciary for in respect of certain things we did under the services.
I may have misunderstood Mr. Hill, but I think
He said we're not a general fiduciary, but that's
I wouldn't assume that Mr. Hill has made any concession on the point.
I'm grateful. My lord, perhaps in the minutes before lunch, maybe, my lord, if we can turn up what the judge's reasoning, just look at the judge's reasoning. What he found. All right, it's tab 13, A166. 53, the answer does not lie in the services agreement. And 54. It says, as explained above, at 54, the mark is not property, therefore it cannot be an asset. The asset is the goodwill of the legacy business. And he says the services agreement is silent on that. Accordingly, the scope of the license, and he's right to use the word scope, because what a license does is it carves out an area of what would otherwise be unlawful and authorises the person to do something within that area. For its own business, must be sought in the general arrangements made in 2007. A conclusion is therefore depending on a finding of fact, and my lord is again right about that. Evidence of the discussion that led to the making of service agreements is admissible precisely because it is not used in aid of the construction of a written agreement, rather in order to establish the terms of a license operating outside of the agreement. And then he deals extensively with the evidence that my learned friend hasn't really sought to go behind in any way. He, from 56 through to 69, he sets out, including the email I've already shown your lordships to. He refers to evidence both in these proceedings and in the first proceedings. He refers to omissions that were made in cross-examination, and he draws his conclusion of fact at 69. In my judgment, the correct conclusion is the license granted to LLP to use the mark as coterminous with the services agreement. I reached this conclusion primarily on the basis of finding the fact that this was the express basis on which the use of the mark was agreed in 2007. Pausing there, on our case, it doesn't matter whether that was a contractual agreement with contractual effect or not. We do not need to rely on any contract. We just need to say that the use was permissive. However vague and imperfect may be the recollection that was discussed, what was discussed. How even if nothing had been said about the matter, I should reach the same conclusion as a matter of reasonable interpretation of the license. And then he goes on to explain his reasoning. And he sets out 70 through to 76, why he therefore concludes that LLP is licensed to use the mark during the continuance of the association with what? That is a finding of fact which we say is unassailable. I will return to the pleading point after I've dealt with fiduciary obligations, because for the reasons I've briefly tried to explain, in my submission they are interlinked.
So you.
I've got 2 minutes. I'm not sure what I can use for you.
All right. Let's play then. How are you doing in time terms?
My lord, I think we're back on time.
Good.
And I'm confident that we will
Excellent.
stick to it.
2 o'clock then.